I'm struggle streaming, family. I don't know. Can y'all hear me? I'm struggle streaming tonight. I might have to cut this and try this again. This ain't looking good, family. They got me, man. Listen, I don't know what they done did with them trees, man. I'm streaming. Can y'all hear me? I'm down in the dumps, man. I'm getting warnings about them struggle streaming and everything. Can y'all see me? Yeah, I'm struggling, man. Yeah. Can y'all see me? I'm struggling. Man. Listen, I had to use Zoom. I don't even like Zoom. I mean, I, had to, I bet you, let me see, I probably look crazy as ever. I'm all right. I'm good. Yeah, family, I'm feeling some type of way this evening, man. Ah, man, I can't do my music. I can't do my intro. Starlight, I'm down in the dumps. I'm kind of suspicious that that my internet acting funny all of a sudden, man. I'm kind of suspicious, man. When them texts come, man, I'm a film these people, man. I mean, Black Bobby. That how you say that? You know I be messing words up. Hey, y'all stop making these names, man, that's gonna challenge my vernacular. Black Barbie Dasotia Patia. Y'all gotta stop doing that. Y'all gotta stop making these names that challenge my intellect. You know what I'm talking about? Anyway, oh my goodness. I even misspelled my word Tariq Lago problems. Tariq Lago problems just got worse. I'm not gonna be here this long. I got a few things I'm gonna share with you tonight. I got a few things. this dystopia. Okay. I try to tell you. Listen. At a certain point in life, man, we don't even care, man. We just do what we do, man. Either you accept me or reject me. You know what I mean? Just accept me or reject me. It is what it is, man. We can't keep on playing these games like we all highly educated, intellectual. Listen, education come in various forms, you know what I mean? And enunciation is not my favorite thing. I don't even care. With how you going to be a grand sheik and you can't even enunciate dystopia? Hey, let me tell you something. Never had to use the word before. Had no. What do it mean though? Dystopia. Dystopia. So can you break it down for me? Help me out. I don't know what it means. What it mean, Crip? Crip be knowing that stuff. He be spelling that stuff out to me. He be like, this taupe. Come on, say it with me now, Grass Sheik. This toe P-R. He with the A-H. Ah. Crip be spelling it out. I'm, I'm glad I know that's my friend because I feel some type of way. He be spelling that stuff out for me. Y'all ever see Cryptonomics do that? Yeah. Somebody hit the Cash App already. Thank you for some coffee or somebody. Hey, man, let me tell you something. I got some people, man, send me $1, $2, $10, $20. I really, really appreciate you. Really do. Man, I'm out here struggling, man. I'm out here working. I'm out here trying to keep up with everything. And I'm also trying to keep this show going just to keep y'all abreast of what's going on. You know what I mean? But I'm copacetic. See, the Starlight say I'll be always positive. I'll be wearing positivity on me. They're my new brand, copacetic. I'm just copacetic. You know what I mean? Yeah, y'all don't see that? Relating to there we go, that word. Relating to or denoting an imagined state or society where there is great suffering or injustice. Oh my goodness. Relating to or denoting an imagined. You in dystopia? Oh my goodness. Hold up now. Hold up now. I been did that. What it do, family? We got some paperwork tonight. Anybody interested in some paperwork? We got paperwork tonight. Yeah, we got paperwork tonight. We got paperwork tonight. I mean, yeah, we got paperwork tonight. Let me see if I can maneuver in this. Now I'm gonna tell you, I might get a little bit drag. I don't know. Might get a little bit drag. I don't know. I'm gonna see what I can do, but I might get a little bit drag. Let me see. All right, I might get a little bit. I don't know. I might not. But we're gonna try this out, man. We're gonna try this out. I wanna share with you a few things. Okay. This is one I want to share with you right here. One I want to share with you right here. And I'm gonna see if I can play this one. Bam, this is one. All right, let me stop that one. And then it's another one I want to play you. Listen, I don't have a lot of bandwidth and all of that, so hey, you're gonna have to work with me. But but anyway, y'all, let me make sure. I don't even want to turn my phone on. That might take other bandwidth that I'm working with too. But if y'all can see me, then I think we good. So anyway, family, I don't have an intro and all that stuff. I want to give you updates. It just got worse. But do y'all remember when Mr. Nasheed did this? Let me know if y'all can hear this. I want to know if y'all can hear this once I get it up and going. You know what I mean? I want to know if y'all hold up, hold up. I want to make sure y'all can hear this. Do y'all remember this? I want to see if y'all can. Anybody remember this? Do y'all remember that? Anybody remembers that? Who remember that? Anybody remember that? What was that? What exactly was that? You say you can't hear it? Oh, you can't hear it, no sound? That's not good. Hold on. Hold on. Let me try it again. What that was a video of Mr. Nasheed. I gotta try to bring it. I don't know. Let me see how do I bring the sound out in Zoom. I never did this in Zoom before, so stand by. Stand by 1 second. Stand by. Stand by. Stand down. Stand by. Demetrius, stand by. Stand. I never did this in Zoom. This the only thing I could use tonight. Zoom. Everything else was shut down. So let me see if I can. If I can. Let me stop the screen share. All right. So let me see. Let me stand by and stand down. All right. I know what I do. I'm going to turn it up so you mic can hear it. All right. I'm going to play it again. See if you can hear it in my mic. We got so much to talk about on tonight's broadcast. Can you hear it in the mic? I'll let you hear it in the mic. My bad. We're gonna ragtag and struggle stream this thing out tonight. You know what I mean? Let me see if you can. All right, let me screen share it. So now the restitution can pop off. Sometimes it's best to just charge something to the game, man. But I digress. But I'm very excited about that. I'm very excited about that victory because and now we set a precedent now, so people they're gonna have to tread lightly with all of that performative trolling and lying and all of that stuff that don't work in the real world. That don't work in real life. All right, yeah, y'all got to work with me now. Hold up, hold up. Let me see. Let me see. Hold up. Audio. Check, check, check. Let me see. Hold on 1 second. Hold on 1 second. I might get this thing right. Okay. Audio voice now coming from position each person's screen. Bam. Okay, you said all of the big ringtones. I never did this before. So all right, I think this might do it. This might do it. All right, this might do it. If it don't work, then let me see. Let's try it again. Very excited about that victory because and now we set a precedent now, so people they're gonna have to tread lightly with all of that
performative trolling and lying and all of that stuff that don't work in the real world, that don't work in real life. That is not working.
I don't know how we gonna do this because I don't know why that doesn't play. Oh, I know what I do. Hold on, hold
Real life. And let's get down to the nitty gritty. We got so much to talk about. So now the restitution can pop off.
Well, allow me to help you out. Allow me to help you out. What's going on in this video is, and I wish I could have done it with with the software that I use, but everything is locked up on my on my system. Or Crip said it was better. Okay, let's try it. Let's try it real quick. Let's try it real quick.
Sometimes it's best to just process. But I'm very excited.
Oh, I know what I'll do. Oh my goodness, I'm struggle streaming. I am struggle streaming tonight, family. My bad. I'm struggle streaming tonight. Um, but what I was going to say is, I'll try to play it again in a minute. So what the video was saying, fam, work with me. I'm struggle streaming, struggle. Um, what I was saying is that in that video, Tariq Nasheed is pretty much bragging, saying that he beat got a judgment on a peace order. So what happened is Tariq went from California to Baltimore to take out a peace order against myself. And for some strange reason, the judge granted it. And Monday night quarterback is something because you like, I didn't know some of the things that was being said about me until I filed for discovery. And then I will find out he would say things like I'm stalking him, that I went to his house, that I went to his children's school. He said a whole bunch of things that was untrue. And in fact, he even said it in court. I was like, man, what? And it had to be clarified. But nevertheless, with that being said, um, I didn't think that they even had jurisdiction over videos, you know. And I still don't, I still think that it was out of order. You know what I mean? However, they granted the peace order. However, they granted the peace order, right? And Tariq would go on YouTube and brag about this decision, and he claims that they set a precedent with this peace order. Do you know what I mean? So hold on one second. I know what I need to do. I need to turn this up. Let me see. I need to turn this up some. Bam. There we go. Now, I think this is it. I think that's what I'm missing. I'm trying to do too much too fast, and I just need to do the most simplest stuff. You know what I mean? Press 7 if you can hear that. Press 7 if you can hear that. Now, if you can hear it, press 7. I think I had it too low, literally. You know what I'm saying? I wasn't paying attention. Are you able to hear it? Are you able to hear it? What did it just say? Couldn't hear it? All right, let me see. Because I can hear it clearly. I can hear it clearly in my ear. All right, let's turn it up. Let's turn it up.
You see? Because a lot of people out there, to be honest, they just people who get harassed online, a lot of black folks out there who get targeted by these Taharka types, they really just don't have the money for a lawyer. But damn it, I do. So
See, okay. See, so what Tariq Nasheed would do is make people believe that I'm actually stalking or targeting him. You know what I mean? When in fact, these videos are covering a public figure and the things that they are doing in the public. You understand what I'm saying? And these videos are is a response to the videos that he done against me, and now we're just covering the story as it unfolds. Just like today, I'm mentioning Tariq Nasheed's name because we are going to talk about the court case. We're going to talk about the court case. We're going to go into the paperwork. But I want to make sure that everybody hear one more time. So this projection, if you will, this projection.
online, a lot of black, you see? Because a lot of people out there, to be honest, they just people who get harassed online, a lot of black folks out there who get targeted by these Taharka types, they really just don't have the money for a lawyer. But damn it, I do. So yeah, he went up in there with that plebiscite babbling. That don't work off the internet. And family, the judge, if Mr. Johnson, Toronto Johnson, aka Taharka Bay, who is not a registered sex offender, let me reiterate that.
Now, over 2 years later, after the damage is done, he says something to that effect. After 2 years later, you follow me? After 2 years later, after all of the damage is done, now he want to try to say that I'm not this. The damage is done. You know what I mean? The damage is done. But anyway, he went to Baltimore and filed this peace order. Now this is the part where it gets good. This is the part where it's get good. So Mr. Nasheed, um, Mr. Nasheed, when I went to file the the defamation, and Tariq would go on and on and on saying how much I'm a registered sex offender. I'm a registered sex offender. And everybody knows how Tariq Nasheed came with the after I went to a blog across the street from the museum. Um, Everybody knows how he went live and says, I just smacked Taharka Bay and ran him off the block. Okay. He went on and on with that, and it goes viral. Hey, no problem. Fine with me. So what many people don't know is, yes, I also filed a lawsuit against that action also. Tariq had been filing lawsuits against people. I mean, Tariq has been filing lawsuits against people for the longest. If you don't know, I can't really screen share and show you on it. He has been filing lawsuits for the longest against people. You know what I mean? In fact, he even says that he's going to keep on filing lawsuits. But I have a legitimate claim, and in this lawsuit here, it's a lawsuit in the United States District Court. Tariq proceeds to try to get it thrown out. Now remember, he said, I got lawyers. Now, and if you remember the last show, he had went through quite a few attorneys. I mean, at least about 5 or 6 of them, if I'm not mistaken, give or take. Give or take. So in this right here, I can't screen share because my internet is messed up right now, but I can read it to you. Do y'all want to read his motion to dismiss? Y'all want to hear this? Y'all want to hear this? Because I really would like to hear uh, it as I read it. You know what I'm saying? I've already responded to it. And then I want to give you, press 7 if y'all interested. If y'all not interested in this update, let me know. But if you're interested, listen, normally I try to raise money and do a pay-per-view. But I know that many of us may not have what it takes to throw around sometimes. So I'm gonna just do this for the faithful Moorish World TV citizens. So, but you need to hear, I think you really would love to hear this. So, this is the motion to dismiss, family. All right. This is the motion to dismiss by Tariq Nasheed and his attorney. It says, to all parties and to their attorneys on the record herein. Notice of motion and motion to dismiss under FRCP rule and memorandum of points and authorities. Date November 18th, 2024. And this is in November. And I kind of hold this stuff, you know what I mean, because I be in the midst of responding. And and remember, I have to respond to these things. I'm not going to read my response because it'll just take too much time. But I can really illustrate my response, what I said. So I'm going to start reading right now. It says, please take note on November the 18th, 2024, at 1:30 p.m., as soon thereafter as the matter can be heard in courtroom 5D on the 5th floor of the above entitled court located at 350 West 1 Street, Los Angeles, California, blah, blah, blah. Defendant will move to dismiss the complaint and each cause of action set forth therein directed at this moving defendant. The motion will be based on the following grounds. The cause of action fails to state claim upon which relief can be granted as to this defendant. The court lacks subject matter jurisdictions to hear this case. Okay, so what this attorney is saying is that the court, the case of action fails to state claim upon which relief can be granted. In other words, what was the damages? You know what I mean? But in my to my defense, I actually did put the damages in there, and I did put what the compensation of damages could be. But this is just the legal wrangling that they do. And it said the court lacks subject matter jurisdiction. Now that means that that I'm not in the proper venue. Basically, if I'm in Baltimore, maybe I should have filed in Baltimore. Well, I did file in Baltimore, and the judge in Baltimore relocated it to California District Court. So when the judge moved it there, it was proper venue. But hey, the attorney still said lack of jurisdiction, subject matter jurisdiction. Nevertheless, hey, it is what it is. It says, please take further notice that at the hearing, this defendant will also move the court to declare this case frivolous. Frivolous. And we all know what that means. Frivolous as it meets the elements of a frivolous claim. You know what I mean? This defendant will be moving for the court to award reasonable attorney fees and penalties for filing a frivolous case. You follow me? So to your point, Lions, then, when you are in another state, there's paperwork that you can file to file a federal lawsuit in your home state. Do you know what I'm saying? So, I forget the name of the paperwork, but I did file that paperwork, and you'll hear what happens in the end. It says, Please take further notice at the hearing that the defendant will also move the court to declare this case frivolous and meets the elements of frivolous claim. The defendant will be moving for the court to award reasonable attorney fees and penalties for filing a frivolous case. The motion will be based on the notice accompanying a memorandum, points of authorities, and declaration of, and he speaks of its attorney, pleading records and files hearing. This is going to get interesting in a minute. Other further evidence may be presented in this matter. It's about to get interesting. This motion is made following the attempt of conference of counsel pursuant of LR 73, which did not take place because the plaintiff did not acknowledge any of my communication attempts. Now, this attorney is saying that she tried to communicate with me and I didn't respond, which is untrue. I never received a letter. I never received anything, but hey, that's not here nor there. But that's the claims that this attorney put forth. You know what I mean? Maybe the attorney sent me an email and I didn't get it, but that's not grounds for non-communication. Anyway, defendant Tariq Nasheed, by and through his attorney, and then attorney name, hereby move the court to dismiss this matter pursuant federal rules of civil procedure. Defendant hereby files a motion to dismiss based on plaintiff claims to be frivolous, failing to state claim upon which release can be granted, lacks of subject matter jurisdiction, fails to reach the bar of federal jurisdiction, and has ignored all plaintiff attorney emails and attempts to engage communication, despite court's notice that it's policy of the court to engage settlement of civil litigation. What y'all don't know is that this case started in Maryland, Baltimore, Maryland, and I've never dropped the ball on any of this. I never came to this social media platform and bragged on anything, but I've never dropped the ball on anything. So now this is the table of contents. I'm gonna put it over here, and then we're gonna just get to the good part. All right, because in some of the table of contents, it actually has case law that is neither here nor there, but I'm going to get you into the introduction. So here's the memorandum of points of authority. You know what I mean? Defendant submits the points of authority in support of this motion to dismiss. This motion to dismiss the frivolous complaint is direct violation of, listen to this, and I want y'all to press 7 if y'all hear this. This motion to dismiss the frivolous complaint in direct violation of Baltimore City District Court filed of February 8, 2024 in the United States District Court for the District of Baltimore, Maryland, and transferred to the United States Court for Central District of California. Background facts. Plaintiff of Maryland resident runs a video channel on YouTube and is featured on Moorish World TV, talking about conspiracy theories in the United States government, amongst other things. Family, when have you ever heard me talk about conspiracy theories in the United States government? I mean, has anybody ever heard me talk about conspiracy theories in the United States government? I don't do conspiracy theories. But that's what they filed with the court. I mean, that's what they filed with the court. Anyway, it goes on to say, early 2022, plaintiff began to continuously and publicly on a YouTube video channel called Defendant a Grifter, a Con Man. I never even used those. I never even used Con Man. I never even used Con Man. As well as other slanderous titles. After several months of this in October 2022, defendant responded to a video slander attempting to clear his own name on his own channel. Do you hear that it seems like, according to this paperwork and this filing, that they're telling the court that I came out of the blue and just started making videos and calling people names. Anybody that watched the channel, no, that's not the case. Anybody that watches this knows that's not the case. But that's what they filed. And the thing about this, This is on the record, and we can trace what happened from the first video all the way up to being called a registered sex offender, all the way up to being putting it on the record for the record to deal with it from a legal perspective. Like, how do people just say stuff when we actually can trace this stuff? Anyway, after several months of this, in October 22, defendant responded to the video slander by attempting to clear his own name. Plaintiff in turn created and posted the video containing defendant's minor children, wife, family, maps of the defendant house. Fam, you know what's funny about that? That was a news story. There was a news story when the police surrounded Mr. Nasheed's house, and I showed that news story from the aerial point of view. Anybody remember that news story? Anybody? Press 7 if you remember that news story. The news story where the news, the helicopter was surrounding the house. They brought Tariq Nasheed out in handcuffs. They used that picture as evidence to try to say that I'm scanning this out. There's a news story. Anybody remember that story? Anyway, that's what they said. To further provoke defendant to act in self-defense to protect his property, family, minor children, especially after the above-mentioned number 5, plaintiff flew to California, proceeded to take pictures and videos of the defendant's place of business. Y'all see how this? Y'all see this? Y'all see this? Aware of plaintiff's previous slanderous videos posts, as well as plaintiff's previous videos about defendant's family, including, I never made a video about that man's family. Never. We clown the pork chop stew. We clown the pork chop stew. But listen to how this thing is written out. Let me just read it out, and then I'll respond after every section. The plaintiff defendants of business to further provoke and misrepresent the defendant. What up, real talk? Defendant, based on plaintiff's disruptive behavior and with concern for the health and safety of his family and his own, asked the plaintiff to leave the premises. Plaintiff refused to leave. Family, all this stuff is on video. This dude, I got the guy riding down the street like a maniac. Now, I got that all on camera. Him riding down the street like a maniac, double parking on the curb. But they try to say, listen to what they try to say, though. Consequently, given plaintiff actions and demeanor on the site, defendant awareness that the plaintiff has a list of court cases against him. I don't have any cases against me. Of domestic violence, and he's still slandering on this thing. And that's the thing about this. The slandering still goes even on the record. Even on the record. As well as plaintiff's previous numerous slanders videos online, defendant concerned for his own safety and his family had the plaintiff removed and escorted outside of the premises. Fam, do we realize all this is on video? This shows you how disingenuous this thing is. Had me escorted and moved off the premises. Family, do we realize that he did a video? Do we realize that he posted a video? Let me go on. This is the court record. This is not me. This is not me. This is the court record. But wait till you read the judge's response. Wait till you read now, I had to respond to it. I'm not going to give my response. I'm going to just read the judge's response in a minute. Okay. Listen to this logic. Listen to this logic. In Baltimore City District Court, considering the petition and the evidence, the court found that there was preponderance of evidence that within 30 days before filing of the petition, the respondent plaintiff in this case committed the filing against the petitioner, harassment, stalking, trespass. Thus, plaintiff harassment, stalking, and trespass, all legally confirmed and upheld. Peace order was granted on December the 8th, 2023, and the plaintiff was ordered that he, now listen to these dates, December the 8th, 2023, shall not commit, threaten to commit any of the following acts against Tariq Nasheed, and then they name other names. Ironically, it doesn't name Peanut. An act which caused seriously bodily harm, et cetera, et cetera. You know what a peace order would say. And it says the emphasis on shall not is court original emphasis, and the emphasis on harassment and by any other means are hereby intentionally highlighted in order to further the underlying fact of number 16. Plaintiff appealed the peace order, de novo. Defendant peace order against plaintiff was upheld on February the 14th. The court ordered plaintiff to remove videos, to move videos of the defendant's wife and children and family. I didn't have no videos up there of his wife, you know, except for the clowning of the stew. On February 8th, 2024, plaintiff filed a frivolous complaint. Now listen to this. On February the 8th, plaintiff filed a frivolous complaint. This is this complaint here. In direct violation of the above mentioned peace order. What is that saying? That's saying that if you violate the law, violate me, that you can have a peace order and now I can't seek justice from the judicial system in the form of a civil suit. Y'all understand what that means? This is saying, I'm going to read it again. It says, on February the 8th, 2024, plaintiff filed this frivolous complaint in direct violation of a peace order. A peace order cannot stop one from filing a complaint. But, hey, harassing an attempt to circumvent the contact clause of the peace order. Do y'all hear that? Press 7 if y'all hear that. Y'all hear that? Please press 7 if y'all hear that. It's saying that. So the strategy was take out a peace order so you not only can try to control my freedom of speech, but also charge control my access to the judicial system. That's what it was all about. Anyway, plaintiff also made unsuccessful attempts in state court to quash the above mentioned peace order. Now, here we go. Failure to state claim. This is that. Now that was their logic and their reasoning, right? Everybody thumbs up this because it's going to get good in a minute. Failure to family, and normally I don't do this. You know, I've been quiet about this for over 2 years. So y'all are privileged tonight. Y'all are privileged tonight because it's coming to a close, and I feel as though I want to bring y'all up to speed. So it says, they got some case law in here, set forth that a claim is frivolous when the claim is intended to harass, intimidate, embarrass the other party, and have no real basis in law. Livingston W. Muslim. The court stated that the case was considered frivolous, and they're just naming court law, case law, to try to substantiate that it is frivolous. So they're just naming all types of court law, case law, to try to establish that it's frivolous. And it says the next claim was lack of jurisdiction, subject matter jurisdiction. A court cannot hear a case upon which it does not have subject matter jurisdiction. A plaintiff invoking diversity jurisdiction bears the burden of proving by the preponderance of the evidence. That's the name of the document. That's the name of the document that you got to file if you're out of state. It's a diversity of citizen, but they call it diversity of jurisdiction. But I think in Maryland, it was a piece of paper that's called diversity of citizen. And so it means that I'm a diverse citizen. I'm a citizen of Maryland, but I'm making a claim against a citizen in California. And so, and they call it diversity. I don't know if she's right on that or not, but anyway, I know that the document was called diversity of citizenship. Diversity of citizen is what I filed in Maryland. And all this stuff costs money, man. Somebody was telling me the other day that they was going to sue somebody on YouTube. I said, you better be ready. It's very expensive. It is super expensive, and you got to keep up because, hey, every month you're going to have something you got to do. I mean, this ain't for the faint at heart. You got to keep up because they will toss your stuff out in a minute. But with that being said, a plaintiff invoking diversity of jurisdiction bear the burden of proving by the ponderance of the evidence the amount in which controversy sees 75,000, and then they got case law. A frivolous claim, failure to state claim upon which relief can be granted, and they coming with all the case law. So I'm not going to read all of this case law. I'm not going to read all this case law. Because that's what you starting. That's it's just tons of case law. So basically, the premise was that I don't have subject matter. The court doesn't have subject matter jurisdiction, and the case is frivolous. And then you heard all of the other things in there. So what I had to do was I had to respond to that. So when I had to respond line for line, right? And then responding to that, what I did was the case is not frivolous because there's video of it. So what I did was I responded with a written response that I filed and digital response. In other words, I sent in videos, I sent in commentary, I sent in everything as evidence, that that a violation had happened. And so I don't have to go into all of that. I mean, somebody said, check my Cash App. Thank you so much, family. I appreciate the Cash App because we gonna walk this one all the way down, family. I mean, we're gonna walk this one all the way down. Thank you so much. Been there, did that Cash App. Yeah, thank you, brother. And thank you, OA. And so now check this out. Y'all ready for this? Now check this out. That was in November. And when that was filed, I had maybe 2 weeks to respond. If that, maybe 10 days. I had 10 days to respond. So this is how this can get expensive. When an attorney that is seasoned files something like this, I'm over here. When an attorney files something like this and you have 10 days to respond, if I don't have an attorney, I mean, that when I first started this case, every attorney wanted 15,000 or better. I'm not sitting around with 15,000 just to throw an attorney. So I had to learn on the job training. You know what I mean? I had to learn on the job training and respond to these things. So don't nobody calling me, oh, Moore know that law. No, I don't. I had a paralegal to help me, and we put our heads together, and that's what it was. You know what I mean? But I continue to do a lot of this stuff. I have no attorney because I can't afford. At that time, I could not afford $15,000 to drop. You know what I mean? But with that being said, you have to respond, and if you don't respond, you can have your case dismissed, right? So I responded, and then we were supposed to go to court in December 2024, and whatever happened in December 2024, before, like a few days before court, I get an email, and the judge says he's going to decide it in chambers. In other words, he's going to look at their claim to dismiss. He's going to look at the evidence that I respond to the motion to dismiss, and he's going to decide it in chambers. And 2 weeks ago, on the 12th, we got an answer. Are you ready for the answer? This is from the United States District Court. Now, I want you to remember everything that I just read to you and then I want you to hear the judge response. Plaintiff Tahaka Abuke Bey, pro se, brings this action against Tariq Nasheed. Nasheed moves to dismiss Bey's claims pursuant of federal rules of civil procedure, Rule 12B, blah, 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 blah. On February the 9th, Bey was preparing for his upcoming show, Moorish World TV, in Los Angeles, California. And basically, I was across the street and I put in my complaint that I was filing a lawsuit, but en route to file the lawsuit, I was also blogging across the street. Nasheed accosted Bey by telling him to get off the block and approaching him in a threatening manner, hurling insults. Now, what I'm doing is I'm writing my complaint according to the video. I'm not writing my complaint according to what I'm trying to do to convince the judge. I'm writing what I experienced and what the video shows. After Bey asked Nasheed to cease and desist his combative behavior, remember, I was backing up. I was like, go ahead now. You better go ahead now. You better go ahead. After Bey asked Nasheed to cease and desist his combative behavior and stop approaching Bey, Nasheed swung at Bey. Bey attempted to get out of the way of Nasheed's blow. Nasheed's actions harmed Bey in his person and reputation and humiliated him. Nasheed then published a series of videos in which he admitted to smacking Bey and running him off the block. These were submitted into evidence. Nasheed also published a video showing the attack. These videos caused emotional and traumatic effects to Bey and publicly humiliated him. Fam, y'all know them videos went viral. They went viral. And man, I didn't hear the end of that for at least 2 years, 18 months. And it's still being talked about. Somebody just put a comment in the comment section just the other day. Nasheed then published a series, based on the above allegations, Bey filed this action against Nasheed. Bey alleges one cause of the action for assault. As relief, Bey seeks damages consisting of economic damages, including medical bills, loss of income, non-economic damages, including compensation for pain and suffering, punitive damages, attorney fees, and cost, interest, and accounting for Nasheed's gains and profits. In other words, when the video went viral, he made money off the video. I mean, he made money off the video. It says, Bey also seeks an injunction ordering Nasheed to retract, remove, and repudiate in full all defamatory and disparaging statements regarding Bey. Bey initially filed this action in the United States District Court for the District Court of Maryland. Nasheed moved to dismiss this case for lack of subject matter jurisdiction, improper venue, and failure to state claim. Order granting motion to dismiss, transfer order EF number 13. In other words, the judge in Maryland didn't dismiss anything. He just transferred it. After finding it had jurisdiction, the Maryland District Court found venue in Maryland improper. Although it has jurisdiction, the venue being improper. And transfer the action to this court, which would be California. Venue now being proper, Nasheed's moves to dismiss Bay's claim under Rule 12b-1 and under 12b-6 for lack of subject matter jurisdiction, failure to make claim. The motion is fully briefed. It's fully briefed now. This heavy stuff here. Now, this is the judge from his chambers just 2 weeks ago. Under Rule 12b-1, party may move to dismiss based on the court lapse subject matter jurisdiction. Jurisdictional attack may be facial or factual. Safe air for everyone versus Maya. A facial attack accepts the truth of the plaintiff's allegation but asserts that they are insufficient on the face to invoke federal jurisdiction. And then they quote case law. Conversely, a factual attack contests the truth of the pleadings. Y'all might be learning some law here tonight. I've learned so much in the past few years. Anyway, a factual attack contests the truth of the plaintiff's factual allegations, usually by introducing evidence outside of the pleading. The party attempting to evoke the court's jurisdiction bear the burden of proof for establishing jurisdiction. And then they quote case law. A court may dismiss complaint under Rule 12b-6 for lack of cognizable legal theory or insufficient facts pleaded to support or otherwise cognizable legal theory. And then it's another case law. To survive a dismissal, here we go, man. Listen, one thing about the federal court, man, and these courts, man, they really do their homework when they look at the possibility of the legalities of some of this stuff. I was amazed of the detail in this. Anyway, to survive a dismissal motion, a complainant need only to satisfy the minimal notice pleading requirements of Rule 8A2. A short and plain statement of claim, Porter versus Jones. The factual allegations must be enough to raise a right to relief above the speculative level. I mean, above the speculative level. I'm not speculating. I got plenty of evidence, right? This is the complaint must contain sufficient factual matter accepted as true to state claim to relief that is plausible on the face. Determination of whether the complaint satisfies the plausibility standard is context specific, task that requires the reviewing court to draw on its own judicial experience and common sense. A court is generally limited to the pleading and must construe all factual allegations set forth in the complaint as true and in the light most favorable to the plaintiff. Lee versus City of Los Angeles. However, a court need not blindly accept conclusory allegation, unwarranted deductions of facts, and unreasonable inferences. Nasheed moves to dismiss Bay complaint for lack of subject matter jurisdiction and failure to state claim. Nasheed argues that this case must be dismissed because the court does not have subject matter jurisdiction to hear Bay claim. In this complaint, Bay alleges that the court has diversity jurisdiction over his claim. Nasheed does not contest diversity exists between the parties. Diversity does exist. I mean, because he's in California, I'm in Maryland. He does not contest diversity exists between the parties, alleging that Bay is in Maryland resident and Nasheed is a California resident. Instead, Nasheed argues that Bay does not plausibly allege the requisite amount in controversy. In other words, there's a bar that you must reach monetarily in order to have a claim in federal court. And the judge in the court will decide if you have met that bar. So you could say, so for instance, you could sue somebody for $250,000, you could sue somebody for $1 million, you could sue somebody whatever you want. But the judge or the court will have to say this meet the standard of that type of relief. Y'all follow me? Press 7. Y'all follow me? Tariq saying that I do not meet the standard of the relief. But with that being said, before transferring this action to this court, Judge L. Russell III of the United States District Court for the District Court of Maryland concluded that Bey is entitled to bring this case in federal court. That Bey is entitled to bring this case into federal court because it has, one second, it has continually independent obligation to determine whether subject matter's jurisdiction exists. The court independently addresses Nasheed's jurisdictional challenge. In this motion, Nasheed asserts that Bey bears the burden of proving that the amount in controversy exceeds $75,000 by the preponderance of the evidence. This is incorrect. In a case that has been removed from the state court to the federal court under 28 U.S.C. 1441 based on diversity of jurisdiction, the proponent of the federal jurisdiction, typically the defendant, has the burden to prove the amount in controversy by preponderance of the evidence. And then it gives some case law. This burden heightens and shifts to the party challenging federal jurisdiction. Also, typically the defendant, whereas here, a plaintiff filed a suit in federal court and affirmingly alleges that the amount in controversy exceeds the jurisdictional threshold. The amount in controversy exceeds $100,000 and seeking not less than $250,000 in damages. In such cases, the legal certainty test applies to determine whether the plaintiff meet the 28 U.S.C. 1332 amount controversy requirement. In other words, I tell you again, in federal court, just because you put a number up there, do you meet that number by what just happened? You follow me? And that's up to the court to decide. But the defendant can say, "There's no way you can prove that. There's no way." But the plaintiff can say, "Of course I can prove that." And then it's up to the court to decide whether there's reason to believe that it can be proven. And if it's reason to believe that it can be proven, then that is a notch in my belt. That's a win. You know what I mean? And now it goes to the next dismissal point, right? Anyway, Bey does not, okay, let me go back. It said, under the test, it must appear to a legal certainty that the claim is really for less than jurisdictional amount to justify dismissal. This legal ground does not appear to satisfy the amount and controversy requirement. The Ninth Circuit has identified 3 situations that clearly meet the legal certainty standard and defeat jurisdiction. When the terms of a contract limit the plaintiff's possible recovery. When a specific rule of law or measure of damages limit the amount of damages recoverable. When the independent facts show that the amount of damages were claimed merely to obtain federal court jurisdiction. Bey does not assert any contract claim against Nasheed, nor does Nasheed identify a specific rule or law of measure of damages that limits the amount of damages recoverable. Nasheed also fails to point to the independent facts that Bey is claiming at least $250,000 in damages only to obtain federal jurisdiction over his claim. In other words, you have to say he's only saying this number so he can go in the federal court. I mean, there's no way he can prove that. But I'm just narrating just a little bit, right? On the face of the complaint, Bey pleads more than $75,000 required amount. He seeks no less than $250,000 compromising economic, and the judge put compromising economic damages, including medical bills and loss of income. non-economic damages, including compensation for pain and suffering, and punitive damages designed mainly to punish the assailant. Nasheed contends that Bay's YouTube audience is not large enough to harm Bay's ability to monetize his channel that would result in more than $75,000 in damages. But this argument does not address the value of the other claims' economic and non-economic damages. It just got bad. It just got worse. The court cannot say that upon the face of the complaint, it is obvious that the suit cannot meet the jurisdictional requirement. And then it gives some case law. Thus, Nasheed has not met his high burden of showing that there is legal certainty that Bay claim is for $75,000 or less. Accordingly, diversity jurisdiction exists, and the court has jurisdiction over Bay's claim. Rule 12b-6, failure to state a claim. Nasheed also moves to dismiss Bay's complaint for the failure to state a claim upon which relief can be granted under Rule 12b. First, Nasheed argues that Bay formally recites the element of the assault cause of action, but does not allege the facts to demonstrate that the assault occurred in this specific situation under California law. The essential element of the cause of action for assault are defendant acted with the intent to cause harm and offensive contact. So let me show you that. So if a person approaches you as if they want to harm you, that's grounds for assault. Y'all understand what I'm saying? You understand what I'm saying? That is grounds for assault. Like no one have to actually, you just got to approach in a threatening manner. Like you all in my space. That is grounds. This is what the judge said. The essential elements of cause of action for assault, and this is why you got to stop paying, people got to stop paying attention to people on the YouTube thing. I mean, people got to stop playing to the people on YouTube, because the first thing people say, oh, he didn't do that, oh, you can't really see this, no. All you have to do is approach somebody in a threatening manner. So there is no excuse to say, well, the thing is grainy. No, that's you, and this is me. I'm backing up. Anyway, the essential element of cause of action for assault are defendant acted with the intent to cause harmful or offensive contact or threatened touch plaintiff in harmful or offensive manner. Plaintiff reasonably believed he or she was about to be touched in a harmful or offensive manner, or it reasonably appeared to the plaintiff that the defendant was about to carry out the threat. Plaintiff did not consent to the defendant conduct. Plaintiff was harmed, and defendant conduct was substantial factor in causing plaintiff harm. And that's the difference between the law and what people think. Because you can hear what people think about the law, but that doesn't make it the law. You follow me? In the complaint, hey, y'all, hey, can y'all throw them likes up? Y'all like this so far? Man, y'all gonna make me read. I got enough to read for a year. Press 7 if y'all like this, man. Y'all like this so far? Huh? Is y'all understanding, and am I missing anything? Thank you for knocking that guy Eric Fleming out there. It just now. This may be the last time I do this, family, because I gotta raise money. I got to work and make money so I can walk it across the finish line. Because I got court coming up this year. You know what I mean? And I got to be able to get to California. I got to be able to, I got two cases, you know what I'm saying? I have 2 cases that I can't drop the ball. I've been spending money to file these motions on and on and on. And so I just got to do what I got to do. But I still got to teach people. I still got to uplift people. And I still got to spend time with you. You know what I mean? To expose the frauds. You know what I'm saying? I still gotta do that. But let me finish. In the complaint, Bey alleges that Nasheed accosted him, and when Bey told Nasheed to leave, Nasheed proceeded to approach him in a threatening manner, hurling assault. Bey also alleges that as he was backing up and asking Nasheed to stop approaching him, Nasheed swung at him. While some of Bey's alleged harm may not qualify damages for assault, Bey seek economic damages, including medical bills, loss of income, non-economic damages, including compensation for pain and suffering, and punitive damages designed mainly to punish the assailant. At this stage, this is sufficient to allege each of the 5 elements to state a claim for assault. Second, Nasheed appears to argue that Bey's assault claim is precluded by a ruling from the Circuit Court of Maryland for Baltimore City, which issued a protection order ordering Bey to refrain from, among other things, threatening or contacting Nasheed. Now, here is the good part. In his motion, and not in a sworn declaration, Nasheed asserts that the complaint is based on the same facts on which Nasheed obtained a peace order in Baltimore City. You see how strategic that he tried to move with this peace order? But watch this. Watch this. But while he was on YouTube talking, I was actually establishing my position from a legal perspective. While he was laughing and bragging and dancing in the end zone, I was in the huddle making sure that justice be served. Now watch this. In his motion, and not in a sworn declaration, Nasheed asserts that the complaint is based on the same facts upon which Nasheed obtained a peace order. In other words, they gave me a peace order, so let's use that to try to get this thrown out. The peace order deemed Bey to have committed harassment, stalking, trespass. This, Nasheed argues, shows that Bey is attempting to adjudicate the same facts more than once, and his claim should be precluded. The doctrine of res judicata provides that a final judgment on the merits of an action precludes the party or their privies from re-litigating issues that were or could have been raised in that action. Then it gives some case law. Determining the preclusive effects of prior decision, a court looks to the law of the state where rendering federal diversity court sits. So let me just break that down to you. That means that if a court already ruled on an action, which he's trying to say that the court ruled on this peace order, that there's no way that I should be having this conversation in federal court. Watch what the judge said. Watch this. It says, under Maryland law, Nasheed must show 3 elements to establish res judicata. The parties in the present litigation are the same or in the privity with the parties to the early litigation. The claim presented in the current action is identical to that determined or that which had been raised and determined in the prior litigation. And there was final judgment on the merits of in the prior litigation. To break it down in the simplest terms, that each claim must match. So the peace order claim and this litigation must be identical, to use that to throw it out. Must be identical. It says, oh man, this man, man, listen, I've been doing this for 2.5 years. This is definitely a classroom, and it was a classroom for me. It says, Nasheed does not address any of these elements. Nasheed fails to establish res judicata. The claims addressed in the peace order does not appear identical to Bey's assault claim at issue here. Both peace orders state that the court finding against Bey of harassment, stalking, and trespassing are based on conduct within 30 days before the filing of the petition. One peace order is dated December the 8th, while the other is dated February the 14th, 2024. In the complaint, Bey alleges that Nasheed assaulted him on or before February the 9th, 2023, without more, including that Nasheed filed one or both peace orders within 30 days of the alleged assault. The court cannot find that the rulings concern claims identical to one at issue in this case, nor can the court decide that the claim at issue in this case could have been raised and determined in the prior litigation. Additionally, a court ruling that Bey harassed, stalked, and trespassed does not necessarily preclude a finding that Nasheed also assaulted Bey. Accordingly, the court cannot find that Bey's claims are precluded. For the reasons discussed, the court denies the motion to dismiss. Yeah. So one of the games that was played was to file a peace order to try to limit me from addressing things on social media and to limit me from my access to the court system, while he would have free access to the court system. Y'all follow me? Well, like for instance, it appears that, okay, I'm going to put this peace order out and then I'm going to weaponize the court system and come at him. And he won't be able to do nothing because I'm going to get this peace order and it will put a brick wall between him and his access to the court system. That's what he thought. But what he didn't know is that I took it out of state court and went to federal court because federal court is more, as you can see, is more meticulous when it comes to dealing with something of this nature. When someone is slick and moving like that, you know what I mean? When someone's slick moving like that, like the federal court, man, I just, you know what I mean? And even the state court in California, I tip my fares to them because, hey, it's been an uphill battle. But let me tell you something, family. I never got on this platform and bragged about anything. I've never got on social media and you know, like Tariq Nasheed did. Yeah, I got money for a lawyer. That's right. My lawyer smacked him around. Anybody ever seen that before? I mean, anybody seen that? My lawyer smacked him around. Yeah, and I got plenty of lawyers. He was bragging. He was going and all of this childish stuff. Then while he was doing that, I'm like, man, listen, man, I got to preserve my name. I got to preserve my name. Without my name, I can't even make a living. You understand what I'm saying? Like, even if I wasn't on social media, I mean, without my name, I can't make a living. People don't even know the struggles that I've had trying to preserve my name and do property management, home improvement, maintenance on people's homes after they. I live in a predominantly melanated city. In other words, we are 90% us here. You know how many people watch this stuff on social media? You know how many people watch this stuff on social media? So it's not like I live in Arkansas. I live in Baltimore City. We are 90% us. Everybody done heard of Hidden Colors. Everybody done heard of this story. You know how many people looked at me and thinking I'm a pedophile, trying to put a flyer on their door to do some maintenance work? Like, come on now. Like, come on now. And the guy has yet to make a public apology. We see a bunch of justification, but apology can't fix that damage. You know what I mean? Apology can't fix that damage. And then to make up the story, like I'm trying to attack somebody, family, and the video is there. So with that being said, family, um, yeah. So I can do this. I can do this. Listen, I got plenty more stories coming soon, but I'm not gonna I ain't gonna hold you. I mean, he said not the word. PDF file. Yeah. But I ain't gonna hold your family. At the end of the day, it should be coming to a close soon. And I'm not even going to talk about it. And I'm not going to be thumbing my nose. Man, I just want to preserve my name. I just don't want my children to be affected by somebody saying that your father was a PDF file. I don't want my family to be embarrassed by a lie that has plagued my circles and have people asking me these crazy questions. You know what I'm saying? So with that being said, family, we almost there, man. I think this is going to end fairly. I expect it to end fairly. I expect it to end soon. And then everybody go on with their life. You know what I'm saying? But I expect it to end fairly and I expect it to end soon. There is more details that I could tell you, but again, I don't jump the gun. I don't jump the gun. I leave it as it is. And once it's done, I'll give you a report, but I won't be childish about it. I won't be sitting up there gloating, whichever way it go. I'm gonna give you the facts as it's presented. That's all I'm gonna do. I mean, I'm gonna give you the facts as it was presented, family. Um, never you'll be bones and skeleton. Um, somebody look at Frank White. Let me get Frank White out of here. Bam. So anyway, family, uh, I don't know how long I've been live, but I usually drop at 12 o'clock. So I don't know why he made that up. I don't know. I really don't know. Maybe we can get an explanation. Maybe we can get an explanation why he would make something like that up. Or where did he get that from? Can we be childish about it, GS? I encourage it. No, I'm like, I don't know. I don't know. I don't know why one would have over 1 million followers collectively over YouTube and would make a statement like that. I don't know. It, like it's like when we grew up and we called each other names and whatever the case may be. That's one thing, but this guy doubled down. He showed paperwork and he went back show after show after show. And I mean, it was vile, it was mean, it was just every element of darkness of the accusatory, the accusation, and I mean, and the energy that came with it. Yeah, it was something different. And everybody know that do I cover stories and I do a series on people in the public doing things that could be questionable. But nobody can ever say that I have doubled down and got down and dirty, lied on anybody, or made it look like that this person uh, uh, um, was something like that. Nah, I never did anything like that. Even the thing with Billy Carson, you know what I'm saying? We made jokes about the underground city. We made jokes about the jet propulsion stuff. We made jokes about this stuff. We made jokes about this investment thing that didn't look right. But I've never jumped out the window like that. Never. I mean, never. But with that being said, family, I appreciate y'all. I was struggle streaming, but maybe this will be maybe I got one more day to struggle stream, and the people should be coming preparing these lines on the internet. I think it's going to be Sunday. So we might be back in business Sunday. I've been there, cash that. Thank you so much, brother. I'm gonna see you in Alabama soon, brother. I'm gonna see you I'm gonna see you in Alabama soon, brother. I need to come back and get some things straight for this documentary. And also, let me thank ER one time for the one time. That's right. Blessings to you, GS. That's been did that cash. And I appreciate y'all, family. So I'm gonna wrap it up. Um, Again, thank you for all your support, family. Thank you, thank you, thank you. And I'm gonna continue to keep you informed as to what is developing, family. However it go. Win, lose, or draw, I'm gonna keep you up to date. Appreciate you. Peace and love. I ain't got no intro or outro because I'm on Zoom. We can hardly hear the what's the name? But we're gonna put in the sound bite tomorrow. I'm gonna fix this thing right. Peace and love.